first case to come before us is State versus Rankin, and each side will have 15 minutes to present their arguments, and the appellant will be able, in this case it's the State of Ohio, the appellant will be able to reserve up to 5 minutes. I want to remind everybody, I know you both argued here many times, but I want to remind everybody that it is going to be videotaped. Well, actually, yeah, it will be videoed, and then it also will be released on YouTube. So please keep your voices up, stand behind the, I can't think what it's called, but stand behind it, wherever it is. And then also, please don't use the name of victims or the names of children or anything. And we just like to tell everybody that just in case the issue may arise. All right, and we're ready to proceed when you are.
Thank you, Judge.
And just let me know, obviously introduce yourself and let me know how many minutes if you want to reserve any.
Thank you, Judge. Good morning. May it please the court. I'm Rick Raley, appearing on behalf of Summit County Prosecutor Sherry Beth Walsh and the appellant of the State of Ohio. If I could reserve 5 minutes in case I need.
That would be great, thank you.
Judges, this appeal presents a clear-cut legal issue, and I think it's been fully briefed, and so you don't have to hear too much of my voice today. I want to be pretty brief. RC 2929.13D requires that trial courts make certain findings before they impose community control for an F2 charge like the one involved in this case. The trial court clearly didn't make those findings, and there is a clear requirement that there must be a remand for resentencing to handle that issue. I outlined in our brief the facts of this case. They're briefly stated at the change of plea hearing as well as at the sentencing hearing. The 60-year-old female victim was coming home from a foot doctor appointment. She was approached by the defendant, who surprised her, immediately started to demand her purse. When she resisted, he continued to kick her, stomp her, drag her, and variously injure her. When the victim cried out about what was occurring, some workers at the property heard the scream and approached the area, and he fled. At the sentencing hearing, the victim appeared via telephone. She explained the traumatic impact of this crime on her, its ongoing effects in terms of how she feels about her safety. She continues to have nightmares. She feels unsafe. Her older sister had to move into her apartment with her. She had to go to the emergency room. She had to miss work for 2.5 months. She had a swollen face, injuries. She received pain medication. After hearing all of that, and noting that the defendant was convicted of an App.No robbery, the trial judge still imposed community control. But there's no indication in the judgment entry or in open court that the judge made any of the findings required under 2929.13D2, which are that the community control would adequately punish the offender, and the community control would not demean the seriousness of the offense. Based on the facts of the matter, in fact, judges, I would say that community control does not adequately punish this offender. We know not only is this offense that the defendant has been convicted of, he was also convicted of an F5 theft case. There's reference in the sentencing transcript that he's essentially been having constant police contact since 2017. I'd also say that this is a very serious offense based on what the victim testified to, well, it's not testified to, stated in open court at the sentencing hearing via telephone. Based on that complete lack of findings, I think this has to be remanded. Before I do sit down, though, I do want to mention in response to this waiver issue that the defendant has raised in their brief, that is the only basis that they have set, that they have defended the trial court's judgment on. I would say there's no requirement under the law that a party at a sentencing hearing has to specifically raise, judge, you have to make certain findings to support your sentence. And I'd analogize this to consecutive sentences as well. We see quite frequently consecutive sentences appeal that come before this court. We don't say, oh, the defendant didn't say at the end, yep, you got to make findings before this comes up. And then we, refuse to remand it, so those remain.
But the prosecution didn't object to the sentence either.
I would very firmly disagree with that. It was not necessarily an objection after the fact that it was stated. It was, hey, you should oppose a prison term.
But there was no formal objection to the sentence.
No, I think at that point, though, it's already been made that we think the community control is clearly appropriate. So I do think there is an objection. Sure, there is no word, I object. But it seems kind of unusual at a sentencing hearing to require the party say, I object. I mean, we're putting our positions at the beginning of the hearing. So I don't see it a requirement under the law that there be a specific raising of this issue. I would also note the change of plea hearing, the judge had mentioned there is a presumption. So it was known that this is what's applying to this particular sentence.
So she did mention that at the sentencing.
The change
I
of
realize
plea.
that there's a presumption in prison here, but I don't think it's necessary or whatever.
She said that the change of plea that it carries a presumption.
Oh, the change of plea.
That the sentence she did not mention it.
Okay, and what is this, I know we have the murder case in front of the appeal right
Correct,
now.
yes.
I don't know what the status of it is exactly, but I know it's not set for oral argument or anything yet. But, and what is the status then? Is he on community control or pretrial release or what?
He's currently on community control, I believe, Judge, that is commenced in this case. His F5 theft, he received time served on that case. So he's currently on community control. I believe he has pretrial release on the murder case.
I thought there was something in this, I'm sorry. I thought there was something in the sentencing that said he didn't have to do community control until after.
I may have missed that, Judge, I'm sorry.
All right, that's fine. I'm sorry, did you have something?
Does it say specifically in the statute that the court has to make these findings on the record?
I believe that under D2, yes, they must be made on the record.
Where does it say that?
The trial court shall make those findings, and it says 1 and 2 what those 2 findings must be. So they have to be incorporated somehow. There has to be some sort of necessary finding. Theoretically, you could look through the transcript, I'd say potentially, and say, well, the judge would have made these findings based on what she said. We can't even look at the sentencing transcript and say that that's.
So there's a presumption of probation on F4s and F5s, so every time a judge imposes prison on an F4 and F5, your position is that they would have to explicitly make those findings on the record.
So for F4s and F5s, Judge, I would disagree with the qualification there's a presumption for that. There's certain F4s and F5s where there's a mandatory community control. If it does not fall under mandatory community controls, the judge has to be guided by the typical sentencing principles that are brought in from Bryce Code. So I think in that situation, I think the record should reflect that there is an exception to mandatory community control, but then I don't think there's a requirement under the statute for that. There has to be specific findings.
So you're saying there's no F4 and F5 where there's a presumption of community control?
I think that is a misnomer that's commonly used in courts. Because the statute does not say presumption for community control, it just says certain cases there's mandatory community control.
And so you're saying, from a review of the transcript, there's no discussion that we could cause or that we could use to determine what her findings were in open court and none in the journal entry either?
I believe so, Judge. It's very brief. She basically listens to the arguments and says, I'm actually going to impose probation. Here's what the terms are.
Doesn't she make reference, though, to him already serving a year on a previous sentence?
She does refer to that. I don't really know how that goes into the findings about this particular case. That would go into why he got time served on the previous case. 1 year extra time, that would just mean he gets jail credit for the 2-year mandatory minimum that the prisoners impose. And if no other questions, I reserve until the fall.
Thank you.
Not used to being on that side of the room.
That's still weird.
Good morning, Your Honors. I'm Alan Bevick. I'm here on behalf of the athlete, Javion, Rankin, who's here in the courtroom with me today. And we unsurprisingly refute the claim that there is a requirement that these findings be made in the record. The state's position essentially is arguing that by not making such findings, this sentencing entry is void, not a voidable matter that would need to be protected by objection. That would be akin to where we at least were at points in the past on post-conviction relief. And if that is the case, then the prosecution's obviously right. This needs to be remanded. I would contend that that's not the position. It's not the position of the Milhone case that I referenced, which seems to be the only case I could find on this particular issue. And I would distinguish the facts and the procedural findings in that case from this one. In that case, there were clear references to specific references to the rebuttable presumption by the prosecutor at both the sentencing and the plea hearing, which did not make the court aware of the statute. The court is aware of the statute, made the court aware of the prosecutor's position regarding that rebuttable
arguments here today, that the court itself indicated that she realized there was a rebuttable
The
presumption.
court stated in the plea hearing, that under a second-degree felony, there's a presumption of prison time. That's a known fact. I mean, we're gonna presume that, I would go so far as to assume that the trial court knows what the law is, under
Well,
all circumstances.
but the only reason I brought it up is because you seem to be saying that they have waived it because they didn't tell the court that
And-
there was a presumption.
What I would say is that when you review the facts of this matter, as Judge Landinger has indicated, there were conversations about the reasons for the community control here. As you have indicated, and there is some confusion in the record, to the point where I myself have questions about the rightness of this. I think my client is currently on community control in this case, but his supervision is being managed by pretrial supervision while in house arrest for the pending murder charge. So, obviously, this was all done with an eye toward that murder case. And the suggestion that by making a request for prison time in this case is a statement, an affirmation of the prosecutor's understanding of the rebuttable presumption and not a waiver of that, or an objection to it is a bridge too far. The prosecution asked for prison time on many sentences, whether there's a rebuttable presumption or not, on an F3, on certain F4s, but on anything, they will ask for time. Mr. Malarczyk, we asked for, we didn't ask for probation on this case for Mr. Rankin himself. We asked for imposition of a prison term, and that he be credited for time served, and that this case be terminated, which I think if the court had done this, I don't think Mr. Raley would even dispute that there would be no question that time served would have satisfied this case, and there would be no remedy, and that would be within statutory guidelines and within that judge's purview. And this judge decided to adopt a remedy that imposed a higher sentence, but did not place my client in an ODRC facility while the murder was pending. They could have stayed the sentence. There were other things to be considered. And right now, I think, there's a matter of harmless error in some of these considerations.
I didn't hear that.
There may be harmless error here, and I'm speaking that out because the alternate would be to impose the 5-year sentence, leave him on pretrial supervision, and just stay that sentence until the outcome of the murder.
So are you saying that the state should have objected to the sentence?
I think the state had an absolute opportunity to do so and to make the court aware of that rebuttable presumption, which they at no point in that sentencing or in the plea hearing did anybody from the prosecutor's office discuss their position regarding that rebuttable presumption, or that the statutory requirements, if those are such, that they need to be in the record, were not met. After Judge Rowland's imposed sentence and said what she was going to do, she asked both the prosecutor and Mr. Malarczyk if there was anything further, and both the prosecutor and Mr. Malarczyk said no, there was nothing else. There was an ample opportunity for the trial prosecutor at that point to say, yes, I do not think you have met those burdens, we object to this community control. That opportunity was there, and they did not avail themselves of that opportunity.
So let's say it's a defendant situation where there's a sentencing problem.
And I think that that is absolutely the consideration here, that I think in those cases, and there are cases such as the Payne case where there were objections that could have been made that were not, that were regarding what the sentences would be. The Payne case, I think, specifically speaks to sentences beyond what could have been imposed based on changes in Supreme Court law. That needed to be protected. It was not.
But we've never said.
The analogy on the other side here, and this is where this would fall, is, and I acknowledge that this is akin to a post-conviction relief notice, and that failure to make that notification voids the entry. This becomes a matter of whether this is a void sentencing entry or avoidable sentencing entry, I think is what we're down to, which is always a horrible place for your court to be. And I apologize to put you there.
No, but what I was going to ask you was, we've never required a defendant, if there's a problem with making findings, that he or she should object.
And that becomes the question, because those entries, those failures to make, well, again, and I would concur with Mr. Raley regarding the findings on 4s and 5s, that there is that I think if you read the statutes, and unlike the second-degree felony, this presumption, which is clear, there is no such presumption of community control for 4s and 5s. I think that is a terminology that is used, and I think it may be a presumption at a case law level, but there is no statutory presumption in the same way that there is for this case. I acknowledge that.
Seems to me like there's many ways, many remedies here. So you're obviously advocating just for a straight affirmance.
I would advocate for an affirming of this case.
That's what
I
I'm saying.
think that of this decision, I think that this has not been protected. I also believe that in review of the record, there were sufficient facts and considerations by the judge, while they may have been, let's call them inartfully articulated, and they were certainly not put into the written sentencing entry. I think she did hear from both the victim and from Mr. Rankin regarding, and did take those into consideration, and did take the factors regarding, she heard from the victim regarding her age, regarding her injuries, regarding her loss of work. All of those factors were considered. She was aware of those. And she also took into consideration the fact that he had this pending sentence and was on these charges. If the alternate, and so I think even factually, and if this court were to consider this for error, I don't think that they meet their burden of showing that she was in error to the prejudice of the state in imposing community control. But
Well, I
also,
guess my point is, though, with the remedies, one remedy would be affirm, one would be reverse, one could be remand for findings.
right, and I think that the alternative here, and I think what the prosecutor has asked for, and I would agree that if you do not affirm Mr. Rankin, the proper remedy would be remand for proper findings, and that's what would generally happen. As I say, again, the closest analogy from a defense side that I can come to is a post-conviction relief or some sentencing error on the defense side, where they've not properly notified the client, the defendant, of his rights. And the remedy for that is remand and correct. And I think that should you not affirm here, that would be the appropriate remedy here. Thank you. With that, I would, unless there are further questions, I would cede the balance.
I don't think so.
Thank you.
Thank you again. I had some more time to reflect on Judge Landier's question about what requirement there is for these findings. I would direct you, Judge, to RC 2953.08G1 that says if the sentencing court fails to make required findings to support the sentence, including these findings, then the case must be remanded. So I would point you to that, Judge. I would want to then go on to Mr. Vettick's reference to this voidable issue. I think that's a red herring. That's not the standard that we're not talking about voidable issues. This whole waiver issue and waiver within criminal cases is about what the standard of review this court is going to apply. Typically, that means if there's a waiver, you have abuse of discretion or plain error. That's not what we have in sentencing. Sentencing is very strict, it's clear and convincing, it applies no matter what. So I think the fact that that's the only standard review that applies is a real hammer to the argument that we had to specifically raise this issue for appeal. The same standard review applies whether we specifically said this presumption applied or whether the trial court mentioned that it applied and then failed to talk about the findings that stated it. And I will just talk briefly about those three options about what we have here: affirm, reverse, remand for findings. The only way to affirm is this court to say that there would be a waiver by the state. And I think that that is a wrong path to go down. Based on how sentencing hearings operate and how it's different from errors that might occur at trial or at pretrial stage. So the options are really reverse or remand just for findings. If this was a case where the transcript included a lot of explanation for why the judge put this sentence down, if there was an indication that those findings were made, I would say that the state would only be able here to ask for that kind of a remand for those findings to be made. And I'd analogize that to situations where consecutive sentences, clearly there was evidence in those records and the trial judge made findings for consecutive sentences, but just failed specifically to state that it's required. That's not what we have here. We have a complete failure to appreciate and make the findings that were required under the law.
But counsel, I will say, whether it constitutes a waiver or not, I'm not presuming either way right now. But, you know, when I was a trial judge back in the old days, and when I was at the prosecutor's office back in the old days, you'd be pounding your fist on the table, screaming at the judge, "What are you doing? You know, this is presumption of prison, and, you know, my gosh, da 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 da."
That goes to trial tactics, Judge, I will tell you that right now. We all have different styles. I may have been like that when
Might avoid some things.
It may be the particular courtroom that they were assigned into this one. This was a very contentious day of hearings that also may have impacted some of that thinking. But I don't think, regardless of those trial tactics, I don't think the law requires a particular one. A matter of best practice, perhaps we can say, yes, you should be saying, there's a presumption, but I don't think that's required under the law, Judge.
Thank you.
So Judge, I would ask you to go ahead and reverse this case, remand it for full sentencing. Thank you.
The court will take the matter under advisement. We appreciate your arguments today, and we will issue a written opinion that will be sent to both sides, as well as it will be released on the Supreme Court website in electronic form. So thank you very much.
Thank you, Judge.